In this lesson, we're going to start to talk about the various different theories and principles of the criminal law. Now, this is going to pertain to some of the more philosophical aspects of criminal law and criminalization, more than the substantive procedural elements of the criminal law itself. So ultimately, this is where we're going to start. We'll start by talking only briefly and do a sort of overview of some of the theoretical principles which underpin the criminal law itself, and then we will essentially be dividing this lesson into two. Essentially, we're going to be doing two lessons here, and we're going to be dividing them into two main theories. And these are the sort of two traditional understandings and traditional theories of the criminal law. And essentially what we are talking about is the sort of rationale and justification for criminalization. Under what circumstances ought something be criminalized? Or better still, what is it that the criminal law is looking to regulate? Okay, in the first lesson, in this lesson, we're going to talk about something known as the harm principle. Okay, we're going to talk about the idea that essentially what the criminal law does in terms of criminalizing conduct is that it is doing so on the basis that that particular conduct causes harm in some way. And then the second lesson, what in the next lesson we'll do, is talk about the idea of criminalization being justified on the basis of upholding morality. This is something known as legal moralism. And we will sort of play off these two ideas and see where we go from there. So essentially, criminalization is the process by which certain conduct is made criminal. Criminalization of conduct, okay? Simple as that. And given that criminalization entails the restriction of an individual's right to perform a certain action, the justification for criminalization is particularly important. So what we're doing is we're restricting an individual's liberty to perform said action. And so in doing so, we have to really have quite a high bar for why we're doing so. We have to explain why it is the case that this action has to be criminalized. And so this begs the question, how does one justify criminalization of conduct? And like I've said at the start of this lesson, the two most prominent theories, or at least the traditional two most prominent theories are in this regard, are the harm principle and the theory of legal moralism. The harm principle being, well, we justify criminalization on the basis that the particular conduct causes harm, or legal moralism is we justify criminalization of conduct on the basis that that conduct is immoral, or it is wrong on some kind of moral level. So looking first then at the harm principle. Essentially, the harm principle is, in its general form, justifies criminalization on the conduct on the basis that the conduct in question that is being criminalized causes harm. Okay, this is the general form. This is just a sort of general overview definition of what the harm principle essentially entails. Now, according to John Stuart Mill, the only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. This is a classic example of the elucidation of the harm principle in some of the more traditional literature. Because what it is doing, it is recognizing, this quotation is recognizing that criminalization involves the restriction of an individual member of a community, and it involves restricting against their will. It involves restricting in the sense that it tells people that they cannot perform this action, and it involves restricting in the sense that if they do perform this action, then the state will come down and prosecute them for doing so. It could also lead to an actual physical restriction of freedom in the sense of prison time. And so what John Stuart Mill is saying is the only way we can wield this power, the power of criminalization, is if that action is harmful, and if criminalization will prevent harm to others, and so as a result of which we can justify the basis of criminalization from that perspective. Now, one can understand the attraction of the harm principle in circumstances such as rape or other sexual offences, or murder or theft, because we can understand quite easily that murder causes harm, okay? It causes harm to the person, the victim who is being murdered. It causes harm to individuals in society. It is a net societal harm if we were to allow murder to take place. And so therefore the state criminalizes conduct such as murder in order to protect individuals from harm, the harm that would be caused from committing said act. And it's not even necessarily direct harm. It is not even necessarily the direct harm of being murdered, but it could also be the sort of general structure of society as well. It would be harmful to the broader society if we were to just allow people to go about individually murdering others. So those are instances where we can understand the harm principle in quite an easy circumstance. Sexual offences, property offences, things like murder or manslaughter, we can understand why they are criminalised on the basis of the harm principle. But can the harm principle explain the nature of criminalisation in all circumstances? Okay, and given that the criminal justice system includes thousands of criminal offences, does it make sense to suggest that harm, say, harm to be prevented in the case of murder in the same way that harm is prevented in the sense of a case of driving without insurance? Now, an individual may go about and have a perfectly ordinary car journey and go from one place to another without insurance. That would be a criminal offence. And you could maybe make the argument that, well, how do we reconcile the harm principle with that being a criminal offence? One answer to this question could be variation in punishment, accounting for variation in harm incurred. So they can both be criminal offences because they both cause harm, but the fact that one causes less harm than the other is represented in the various other factors which are attached to the criminal justice system. Of course, the punishment for murder, being found guilty of murder, is very different to the punishment of being found guilty of driving without insurance, for example. And so as a result of which, the relative differentiation of harm is representative here in the idea of the different punishments that are being put across depending on the particular offence. Now, legal theorist Joel Feinberg has suggested that while the harm principle could be useful in understanding the idea of criminalisation, not all conduct which causes harm may be criminalised. So he suggests that the harm, the idea of just harm in and of itself, may not be a sufficient condition for the establishment of criminalisation or for the justification of criminalisation. He suggested instead that there may have to be additional factors which ought to be considered, including the gravity of the harm, the magnitude of the risk, as well as the relative probability of the harm being caused. We can understand the harm that is caused by murder, for example, but what about the harm that is caused by just giving somebody a shove, pushing an individual? That is a crime. That can be considered a criminal offence. That can be assault and battery. However, the distinction here is the gravity of the harm has to be weighed up against the A, likelihood of conviction, and B, the resource expansion that is caused through the prosecution of particular offences. So there has to be balance here. You can't just suggest that harm in and of itself in a generic definition is a sufficient condition to justify all criminalisation, according to Feinberg. Instead, there have to be other conditions that we have to think about, like how harsh, how grave is the harm, what is the magnitude of risk that harm is going to be caused, what is the relative probability of the harm being caused. We also have to ask the question of subjective harms. The issue is that not all acts can be considered harm to everyone, or that they may be acts that are considered to be harm to everyone, but they're not considered harms in every single in equal fashion across every single type of offence and across every single person in society. We can all essentially agree, for example, that harm which is caused by murder or sexual offences is definitely a harm that we can all agree is considered harm, okay? But there are some instances where it might be more difficult to see harm, or where some people see harm more than others. So, for example, selling an energy drink to somebody who is 15. Now, the law at the moment states that you have to be 16 to purchase an energy drink. but a 15-year-old purchasing an energy drink might not necessarily be that harmful. But some people might argue that it is. It could be a subjective argument that is presented here. And so as a result of which, some of the ways in which we can classify and understand the harm principle as a justification for criminalization falls into doubt or falls into some kind of scrutiny. Which is why we also have the second major traditional theory of criminalization, which is, of course, this idea of legal moralism, which we're going to get to in the next lesson. Hello, everybody, and welcome back to the criminal law. In the previous lesson, what we did was talk about the concept of the harm principle as a way of justifying criminalization of conduct. And this sort of ties into some of the basic theories and principles of the criminal law. Now, this lesson, we're going to essentially talk about the next of the major theories, or at least the second of the major theories of two, which is this idea of legal moralism and this idea of crime and morality. So, like I said, the previous lesson introduced the traditional theories of criminal law and criminalization. And we spoke at length about the concept of the harm principle, and this lesson we're going to talk about the concept of legal moralism. Now, ultimately, the concept of legal moralism, essentially the thesis that is presented, the argument which is presented by legal moralism, says the following. It argues that criminalization may be justified on the basis that the particular act in question, or the omission, or whatever we are looking to criminalize, violates some kind of moral standard or moral principle. That is a sort of general thesis. Of course, there are specifics in terms of specific theories within this idea of legal moralism, within the tradition of legal moralism. Some people may argue that legal moralism cannot ever be a sufficient condition for criminalization, or at least for justifying criminalization. And in fact, there ought to be other necessary factors which go along with it. However, this is just a sort of general thesis of what legal moralism states. Now, it also means that if something is a crime, it may be a crime not necessarily because it causes harm, but because it is immoral. Now, you might be of the opinion that every single thing or anything that causes harm can be considered to be immoral. And so you can almost have legal moralism as being a more all-encompassing criminalization theory to that of the harm principle. But the thing that legal moralism does is it takes it one step further and talks less about harm specifically, but talks more broadly about the idea of morality and moral standards. Now, the concept of the harm principle and the idea of legal moralism may even be encompassing be able to be encompassed into the idea of legal moralism. You could say, for example, murder is wrong, or at least murder ought to be criminalized because it is immoral and it is wrong. It is immoral and it is wrong because it causes harm. So you could almost have it as a two-stage test in that regard. Now, the question and the critiques that we can then start to think about is whether or not it ought to be the case that public morality be considered the remit for the criminal justice system. Should there be an interlinking, an interconnection between the criminal justice system and this idea of public morality? Is this idea of public morality sufficiently codified such that we understand it enough to be able to allow the criminal justice system to intervene within it? What about acts which are considered to be perfectly legal, but at least 30 years ago were considered to be immoral? For example, things like homosexuality. What about acts which are considered to be immoral, but are not taken up by the criminal justice system, and we would argue shouldn't, or probably ought not be taken up by the criminal justice system? For example, cheating on a significant other. These are both examples which really beg the question as to whether or not legal moralism can be, in and of itself, in its generality, an accurate principle for talking about justifying criminalization. Because on the one hand, you can criminalize conduct which is considered to be immoral, but in reality is completely legal and perfectly moral, like things like homosexuality. And on the other hand, you can think of things that I think the entirety of a public society would argue is an immoral act, like cheating on a significant other, but that ought not be taken up by the criminal justice system. We ought not to justify criminalization of adultery on the basis of the fact that it is immoral. So, one of the things that is very interesting with this and talks about the interrelationship and the interaction between this idea of public morals and the criminal justice system is the development of two offences in the 1970s which surround this idea of public morals. So there are two specific offences, common law offences, which were developed in and around the 1970s, and these were conspiracy to corrupt public morals and also conspiracy to outrage public morals. Now, in addition to this, the application of these offences can be seen in two cases, one concerning prostitution, the other concerning homosexuality. And let's talk about these in turn. Let's talk first about Shaw and the Director of Public Prosecutions from 1962. In this case, the defendant had created a number of magazines, and included within these magazines were the personal adverts for prostitutes to be able to advertise their services, and for that to be then advertised in the magazines. Okay, and given the fact that the defendant had made money from selling the advertising space, so this is something that is probably done less and less today owing to the fact that we have the internet, but back in the day, back in the 1960s, magazines were a very good way to advertise your products, to advertise your services in the case of prostitution. And so people who would distribute magazines or own magazines would make quite a lot of money from being able to sell advertising space. This individual here, the defendant here, had done so by selling advertising space for prostitutes to advertise their services. They were charged and convicted with conspiracy of conspiracy to corrupt public morals. Now, in addition to breaches of the Sexual Offences Act of 1956, so this is Section 30. So the thing that is more important for us is less the statutory offence which is attached onto this case, which is Section 30 of the Sexual Offences Act, but specifically this idea of the fact that they were charged and convicted of conspiracy to corrupt public morals. The defendant would appeal the conviction, at least appeal the conviction of the conspiracy to corrupt public morals, on the basis that, and given the fact that this was not considered an offence in the law of England and Wales, and so the defendant here argued that they ought not to be convicted of an act which is not actually an offence. The appeal was dismissed, however, and the conviction was upheld, and this therefore created a new criminal offence in the process, which was that of a conspiracy to corrupt public morals. A few years later, a very similar case takes place, which is the case of Nuller and the Director of Public Prosecutions again. Again, this was a case which involved the defendant publishing magazines for distribution. These magazines, instead of allowing people to advertise prostitution and to advertise their services as prostitutes, this magazine allowed people to advertise, individuals to advertise personally themselves for homosexual practices, essentially. I'm putting homosexual practices in sort of inverted commas, considered the kind of formalistic language that implies. Now, again, the defendant was convicted for conspiracy to corrupt public morals, along a similar basis to the previous case of Shaw. Now, the issue again was whether or not this was an offence which is recognised by England and Wales, and just like with the previous case, this was dismissed, and therefore reaffirming the creation of the offence and reaffirming the decision that was made in Shaw and the Director of Public Prosecution. Now, as you can probably understand, and as you would probably note, at least at the time, these were relatively controversial cases, but now these cases are both incredibly controversial, as you may understand. There was also scrutiny of these kinds of offences under the Wolfenden Committee report, which was in 1957, and it was the Committee report on prostitution and homosexual offences. And here what the committee essentially held was that the criminal law ought not have a role in the enforcement of public morality. And that given that morality is a subjective endeavour, as we probably know, without getting into the sort of depths of the meta-ethical theories of morality, we would note that morality is often considered to be subjective. It differs from one person to another as to what people view as moral versus immoral. There are some people today who believe that things like homosexuality is immoral. The regulation of public morality under something like the criminal law is something that could be considered to be controversial. And so as a result of this, it really leaves legal moralism in quite an interesting question. The question is whether or not we can justify criminalization on the basis of morality, or a lack thereof of morality in the particular act. And this is an interesting debate that will continue to be had, and when we get into looking at some of the philosophies of criminal law in more detail in future lessons time, I'm sure we'll go into this in far more detail. Welcome back, everybody, to the criminal law. We're continuing to talk about the theories and principles of the criminal law. We're going to focus in this lesson on theories of punishment. Now, again, just like with the previous lessons that we've been doing, talking about the sort of justification for criminalization, theories of punishment is, of course, a theoretical discussion in and of itself that probably merits its own separate series of about 30 or so lessons. So we're only going to be really scratching at the surface in this video, because the aim is to just provide some of the theoretical groundings for how the criminal law operates, and some of the ways in which we can understand the criminal law from a theoretical perspective. But we're going to be soon shifting away from theories of punishment, theories of criminalization, all these ideas of the philosophy of criminal law, and moving into actually the procedural and substantive legal and doctrinal ideas behind the criminal law itself. So, like I said, we've been exploring some of the basics and some of the major theories of criminalization. We looked at harm principles, and then we also looked at the concept of legal moralism. This lesson is going to talk about the theoretical underpinnings of the sort of end result of the criminal law, the finding of an individual guilty of an offence, and then looking at what the purpose of punishment really is. The idea of we know that punishment exists. We know that if an individual is found guilty of an offence, depending on the offence, you may be fined, you may be subjected to community service, you may be subjected to a prison sentence. But what are the theories behind that? Why is it the case that an individual is subjected to, say, a prison sentence or to community service? What purpose does that serve for broader society? So, where an act may be criminalised, the result is that if one is found guilty of said act, there will be some kind of punishment. Now, we can justify punishment on a number of different bases, and essentially we need to justify the need to include punishment as part of the broader criminal process. We're going to look at 4 of the common justifications for having punishment as part of the criminal process in this lesson. The first of which is this idea of deterrence. Now, I will also like to preface this lesson and preface this before we look at these different theories of punishment in more detail by making clear that I'm not going to suggest that all of these may be correct, or that some may be incorrect, or some may be more valuable than others, or some may be more important than others. I'm simply going to be quite descriptive in my explanation of each of these different theories. And so for the first one, we're going to talk about this idea of deterrence. Now, this is the theory that the idea behind punishment is to essentially deter those other people from committing a crime, essentially to deter others from committing said crime. So the idea here is if you see someone who has committed theft and then they are then subjected to quite a hefty punishment, they may be subjected to some prison time, that punishment seems so bad that you don't want to do the same thing. That's going to deter you from committing that offence as well. So if, for example, there was some crime of benefit, like an act or an omission which would benefit you in some way, like theft or fraud, then you'd be more likely to do it in circumstances where there is no punishment attached to the performance of said act, or where the risks outweigh or do outweigh the reward itself. It's too risky. The risk of getting caught and then being sentenced to a hefty prison time, for example, or a hefty fine or quite a significant punishment, outweighs the reward that it would be had if you committed theft or fraud, for example. So when it comes to crimes of benefit, this may be one way in which we can justify the existence of that punishment. You may be able to say, well, if you're going to benefit from said crime, if you're going to somehow come out better, and there are lots of crimes in which this may take place. I've just written here 2 of the dishonesty offences, but there may be others. Then therefore you may feel like you are going to be less likely to commit that offence if you believe that the punishment would be so severe. So when one may be deterred from committing a crime in this nature, they have to know that they run the risk of being punished in some severe way. And so what deterrence often does is justify not only punishment, or potentially justify punishment, but then also justify quite significant punishments. So if, for example, the committing of theft resulted in only a £4,000 fine, if the theft that you're going to commit is for a lot of money, for potentially more than that, then you're not going to be that deterred from committing that offence, because the punishment isn't particularly hefty. So this therefore causes a deterrence-based mindset within punishment theory to essentially allow for and to justify more and more severe punishments. So if, for example, the death penalty was on the agenda for somebody who committed theft, then the argument goes that you are less likely to commit theft because the risk of death, essentially, for the relatively minor reward of committing theft or fraud, might be a deterrent to that particular offence. So you end up having quite significant punishments for the crimes that you are talking about, and that's one way in which deterrence not only justifies punishment, but then justifies quite severe punishment. The second justification for punishment is a rehabilitative format. So the idea here justifies the existence of punishment in that where there is punishment, there can be a certain degree of rehabilitation. So the aim is essentially getting those people who are found guilty of an offence to go through a process of punishment where they then learn the errors of their ways, they learn what is wrong, what is right, they learn about how to behave effectively within society, and that they come out of this punishment process being reformed and therefore re-entering into society in a new reformed way. And though what this does is treat punishment not necessarily as something that you do as penance for the crime that you have committed. It's not necessarily to deter people from crimes either, but rather it is for you to essentially reform individuals in a way that means that they do not commit crimes again. And so the aim here is that you, by implementing a rehabilitative format of punishment, you are then going to reduce what is known as the rate of recidivism, the rate of reoffending. So the rate of an individual coming out of prison, for example, or coming out of a particular criminal punishment and reoffending, doing the same thing again or doing something similar again, and being forced to live through this cycle of punishment and offence and crime committing and then more punishment. So rehabilitation. And this idea influences the type of punishment as well, because rehabilitation, therefore, does not suggest that punishments ought to be horrible or ought to be terrible. They ought to be a way for people to reform. And whatever that mode of reform is, whatever way that is that works the best, is the way that rehabilitation ought to be implemented, the way in which punishment ought to be implemented. So it doesn't justify further and further and harsher punishments. It rather just focuses on the individual and the ability for the individual to not commit crimes again. A third justification for punishment is this idea of retribution. A retributive theory of punishment essentially asserts that people who are found guilty to have committed an offence ought to have something bad done to them as a way to give them their just deserts, as a way to sort of be retributive to the bad thing that they've done to some other person. So, for one, this is understood as the more colloquial meaning behind the idea of punishment. Punishment, sort of in a colloquial sense, is described as something of a retributive idea. The idea that you've done something bad, well, because you've done something bad is going to happen to you. Essentially, a sort of an eye for an eye perspective. Now, the idea here, you can see when we look at more heinous offences, when you look at some, for example, serious sexual offences, or even sexual offences involving children, there is almost a perception within society that retribution is required. Something terrible has to be done to that individual as a way to try and justify, or as a way to try and balance the wrong that has been committed by said individual in question. And so for the most part, this also assumes that criminals should not be subjected to punishment which is not proportional to the harm that is caused. So each of these theories, as you notice, kind of informs the type of punishment that is going to be applied to different offences. So, for example, with deterrence, there is often a justification to have quite significant punishments for offences to try and stop others from doing the same offence. With rehabilitation, the type of punishment is depending on entirely whether or not it reforms the person who is going to go through said punishment. But with retribution, you're sort of supposed to, you look for this idea of an eye for an eye. You have this idea of proportionality, that you should be subjected to the kind of punishment that to a kind of bad that is proportional to the kind of bad that you have committed. So, for example, smaller offences may require smaller punishment. Larger offences require quite large punishments. That is the idea that is presented within this particular idea. Finally, then, we have this idea of incapacitation. This is the final theory of punishment, and it asserts essentially that in some cases there may be individuals who are a danger to society, and the purpose of punishment is to remove them from society. Now, this again operates on the basis that it depends on the particular punishment in question. So the imposition of a prison sentence may be the best way of keeping people outside of society, bringing them out to protect others. And so this is another theory in which we can see the type of punishment being implemented. This doesn't necessarily work for instances where the punishment is a fine or some kind of fixed penalty notice, but it is something that may work for individuals who commit quite serious offences and therefore need to be taken out of society and put into prison to essentially keep the rest of society safe from that individual who may be a danger to the society in question.